Welcome to Law and the Machine, where artificial intelligence meets the legal system. Liability, regulation, intellectual property, and the government's uncomfortable role as both rule maker and AI adopter. The law wasn't written for this.
Imagine a scenario playing out in the highest court of a state. The Chief Justice stops proceedings, looks directly at a prosecutor and says, "There are at least 5 citations to cases that don't exist, and there's at least 5 more citations to cases that do not support the proposition for which they're cited, including 3 quotations that don't exist."
And this isn't some minor traffic infraction or a civil dispute over a parking ticket. This is a murder appeal. A woman's life in prison is on the line, and the state's argument for keeping her there is built, in part, on fabricated legal precedent.
It gets wilder. The prosecutor, a Clayton County assistant district attorney named Deborah Leslie, initially tries to deflect blame, even suggesting the trial judge might have altered the document. But the Chief Justice, Nels Peterson, quickly shuts that down, pointing out the phantom cases were in her original brief.
Which, of course, led to her boss, DA Tasha Mosley, publicly contradicting her own ADA, stating there was a clear policy that AI should not be used, and reiterating the fundamental rule: you don't lie to the court. And then an order from the court demanding an explanation, leading to Leslie's sworn admission. She used AI for expanded legal research, and it hallucinated the case law.
This isn't just an embarrassing gaffe, is it? This is a fundamental breakdown of the legal system at a critical juncture.
It's an absolute crisis.
This all centers on the appeal of Hannah Payne. Can you briefly walk us through the gravity of that case?
Absolutely. This isn't a low-stakes civil matter. It's literally about a person's life and liberty. Hannah Payne was convicted in December 2023 of malice murder, felony murder, aggravated assault, and false imprisonment. She was sentenced to life in prison plus 13 years. The charges stem from a truly tragic incident in 2019 where she witnessed a minor car accident, called 911, and despite dispatchers telling her not to pursue, she chased the driver, Kenneth Herring, for about a mile. She used her car to block his, approached him with a gun, and during a struggle, Herring was shot and killed. The prosecution painted her as a vigilante. Her defense argued Herring grabbed her and the gun went off. So what we're talking about here is a life sentence, an appeal, and the state's duty to uphold justice.
And in that context, the state's attorney used fake law to argue for keeping her in prison. That shifts this from professional malpractice, which we've seen in civil cases, to something far more severe.
Precisely. When a private attorney uses generative AI to draft a personal injury brief and it hallucinates, that's professional malpractice. You might get sanctioned, face disciplinary action, perhaps even lose your license. But when a prosecutor does it, especially in a case with such high stakes, it veers into constitutional crisis territory. Prosecutors aren't just representing a client, they represent the sovereign state. They have a higher duty of candor to the court and a constitutional obligation to seek justice, not just convictions. The state wields the power to strip a citizen of their liberty, even their life. To have that power leveraged using fabricated, machine-generated legal authority, it's terrifying. It's the state using synthetic, hallucinated realities to execute its police powers.
And the district attorney, Tasha Mosley, defended her office by saying there was a clear policy that AI should not be used, but that policy clearly didn't work.
And that's where the rubber meets the road for me, from a systems and technology perspective. An administrative policy, on its own, without a robust technological or human-in-the-loop workflow, is just a piece of paper. How does a major appellate brief in a high-profile murder case, one arguing before the state Supreme Court, make it out of a district attorney's office without a single human being checking the citations?
You'd think that's standard procedure.
It is standard procedure. In traditional law firms, junior associates or paralegals have the critical job of cite checking. They use databases like Westlaw or LexisNexis to ensure every case cited is not only valid, but actually supports the proposition it's claimed to support. The fact that the Clayton County DA's office allowed this to happen points to a systemic failure of institutional rigorousness. It's not just an individual ADA using AI, it's a breakdown in fundamental quality assurance.
And the adversarial system, which is supposed to be the bedrock of our justice, is built on the idea that two sides fiercely contesting each other's claims will uncover the truth. But in this case, both sides seem to miss it.
That's perhaps the most shocking admission from the Georgia Supreme Court hearing. Hannah Payne's appellate attorney, Andrew Fleischman, actually admitted to the justices that he also failed to catch the fake cases in the state's brief. He said, and I'm quoting here, "I sometimes don't read all of the cases that my opponents brief and the sentences where I didn't do that. I regret that I did not bring this to the court's attention."
Wait, really? The defense attorney, whose job it is to scrutinize every argument made by the prosecution against his client's freedom, didn't read the cases the prosecution cited?
That's what he said, on the record, and it compounds the problem. If the prosecutor hallucinates the law, the defense attorney doesn't read the law, and then, as the source material points out, the trial judge, Judge Jewel Scott, had apparently adopted the prosecution's drafted order, complete with the hallucinated citations, without independent verification, then the entire adversarial system collapses. It's an utter failure at every level.
You'd think by now, with all the warnings, all the headlines, lawyers would be acutely aware of the risks of blindly trusting generative AI, especially in Georgia, where there have been highly publicized sanctions.
That's what makes this even more baffling. ADA Leslie cannot claim ignorance of the technology's flaws because the warnings were flashing red in her exact jurisdiction. Just months before, in October 2025, the Atlanta Journal-Constitution ran an investigation highlighting that Georgia courts were already cracking down harshly on AI use. We saw Jonesboro attorney Laletha Hale sanctioned by a U.S. district judge for filing AI-generated fake arguments in a lawsuit involving comedian Cat Williams. She was ordered to notify all her clients and judges of her AI use for the next 5 years.
5 years? That's a pretty heavy penalty.
Exactly, and it wasn't an isolated incident. Atlanta lawyer Diana Lynch was fined $2,500 by the Georgia Court of Appeals for bogus AI citations that made it into a divorce order. Another Atlanta attorney, Brian Brady, was fined $1,000 in Valdosta federal court for citing 9 fake cases. Despite these highly publicized local sanctions, a prosecutor in a neighboring county made the exact same mistake in a murder trial. It truly beggars belief.
So why are smart, highly educated professionals, people whose jobs require precision and adherence to facts, repeatedly falling into this trap? What is the fundamental misunderstanding of these LLMs?
It's a category error. Lawyers are treating large language models like ChatGPT or Claude as if they are search engines or traditional legal databases like Westlaw or LexisNexis. They are not. These LLMs are probabilistic prediction engines. They don't look up information from a repository of facts. Instead, they perform what's called next token prediction. They calculate the statistical probability of which word should follow the previous word based on their vast training data.
So it's essentially a very sophisticated autocomplete.
Exactly. Think of it like that. Legal citations, especially for court cases, have a highly structured and syntactically predictable format. A Georgia Supreme Court citation looks like name, v. name, volume, ga, page, year. Because this format is so rigid, an LLM is exceptionally good at predicting what a citation should look like. It will string together a highly plausible-sounding case name, say State v. Smith, assign it a realistic-looking volume number, and then generate a perfectly formatted quote written in convincing legalese. The AI doesn't know that the case doesn't exist. It only knows that the sequence of words matches the statistical pattern of a legal brief it's seen countless times in its training data. So when lawyers ask an LLM for case law, the machine, in its probabilistic wisdom, obliges by simply counterfeiting it. It's not retrieving, it's generating.
That's a really crucial distinction that seems to be lost on a lot of people. It's not a smart library, it's a very convincing storyteller.
A very convincing storyteller that has no concept of truth or falsehood. It's just predicting the most statistically probable next word. And the output looks authoritative, which is part of the trap.
Given all this, courts must be scrambling to figure out how to manage AI in legal practice beyond simply banning it, which clearly isn't working.
They absolutely are. It's clear that outright bans, like the one DA Mosley's office ostensibly had, are futile. The technology is too ubiquitous. So in late 2025 and early 2026, state court systems started scrambling to issue realistic guidelines. New York, for instance, in October 2025, released its interim policy on the use of artificial intelligence. It mandated that AI must not be treated as a substitute for human judgment and strictly prohibited entering confidential info into public AI platforms. But crucially, it allowed the use of approved AI products, provided humans verified the output.
So it's not a ban, but a use with extreme caution and verification policy.
Precisely. New Jersey took a different tack in January 2026, mandating that, starting in 2027, all licensed attorneys must obtain continuing legal education credits in technology-related subjects, explicitly including the ethical use of AI in discovery and brief writing. These are proactive, educational approaches that acknowledge the reality of the technology. They stand in stark contrast to Clayton County DA's failed "just don't use it" policy.
That makes a lot of sense. So we have prosecutors hallucinating legal precedent, the adversarial system failing, and a fundamental misunderstanding of the technology's capabilities. But the issues around AI in government don't stop there. This brings us to a recurring theme.
This theme focuses on cases where the lines between AI regulator, contractor, and lobbyist blur, especially when the government is acting as both rulemaker and a massive AI customer.
And this time, we're looking at a new federal procurement rule that seems to completely undermine all the public talk about AI safety.
You're right. In March of this year, the General Services Administration, or GSA, which is the procurement arm of the federal government, published a draft contract clause titled Basic Safeguarding of Artificial Intelligence Systems. This clause is set to be incorporated into GSA's massive multiple award schedule contracts, and while it includes standard cybersecurity and disclosure requirements, it contains what some legal analyses are calling a poison pill for AI safety.
A poison pill? How so?
Because according to firms like Baker Botts and Gibbs & Dunn, this clause explicitly forces AI vendors to override their commercial terms of service and strips away their ability to enforce their own safety restrictions. The exact language of the proposed mandate says, the AI system must not refuse to produce data outputs or conduct analyses based on the contractor's or service provider's discretionary policies.
So if an AI company builds ethical guardrails into its system, say to prevent it from generating instructions for biological weapons or mass surveillance, this GSA clause would effectively tell them, too bad, government contract trumps your ethics?
Exactly. It explicitly states, in the event of a conflict between this document and any policies, requirements, terms, conditions, or commercial agreements of the contractor or the service provider, this clause controls. This targets the operational safety layer of AI systems, the system prompts, the trust and safety filters, the use case restrictions. It means if an AI company has an ethical policy preventing its model from creating racist propaganda or aiding in certain types of surveillance, for a government contract, that policy is essentially outlawed. The government is demanding an irrevocable, royalty-free license to use the system for any lawful government purpose, and the vendor cannot say no.
That is absolutely wild. It's like the government is saying, we want you to build safe AI, but when we buy it, take all the safety features off. What prompted this aggressive move?
To understand why the GSA issued this aggressive clause in March, we have to look back just weeks prior to February 2026 and a very public standoff. Anthropic, an AI company that positions itself as one of the most safety-conscious of the major labs, they're the creators of the Claude model, was in negotiations with the Department of Defense. The DoD insisted that Anthropic's technology be available for all lawful uses.
Which sounds reasonable on the surface.
It does, but Anthropic refused.
They supported general national security applications, but they maintained strict terms of service prohibiting their AI from being used for two specific things: mass domestic surveillance and fully autonomous lethal weapons. They had ethical guardrails in place, and they stood by them.
So the company known for its safety-first approach wouldn't budge on its core ethical principles.
And when negotiations broke down ahead of a February 27th deadline, the Trump administration retaliated with overwhelming force. First, President Trump posted on Truth Social, directing every agency in the U.S. government to immediately cease all use of Anthropic's technology, calling them left-wing nut jobs trying to strong-arm the Department of War.
Wow, from the White House.
And then, Defense Secretary Pete Hegseth took the unprecedented step of designating Anthropic a supply chain risk, a label historically reserved for foreign adversaries and espionage threats like Huawei. Hegseth stated, "America's warfighters will never be held hostage by the ideological whims of big tech."
So a company refusing to allow its AI to be used for mass domestic surveillance or fully autonomous lethal weapons is now a supply chain risk to national security?
That's the government's argument. Anthropic naturally sued, and in late March, a U.S. district judge granted a preliminary injunction halting the DoD ban, calling the supply chain risk designation likely both contrary to law and arbitrary and capricious. What's also notable is that shortly after the Pentagon banned Anthropic, rival OpenAI struck a defense deal, highlighting the market advantage of dropping ethical guardrails for government cash.
So we have the government publicly demanding AI safety and regulation, hauling tech CEOs before Congress to ask about their guardrails.
But then, the moment an AI company actually enforces those guardrails against the U.S. military, the government designates them a national security threat and rewrites federal procurement rules to explicitly outlaw AI safety filters. It's a complete contradiction.
It's more than a contradiction. It's hypocrisy that undermines the entire regulatory narrative.
It really does.
So, to synthesize all this, what are the key takeaways you think our listeners should really sit with?
First, the Hannah Payne case shows an alarming escalation of AI-related harm. We've moved beyond embarrassing civil blunders to literal life-and-death constitutional due process violations. Second, the failure of paper policies. D.A. Mosley's clear policy banning AI was functionally useless because it lacked any real technological or human verification workflow.
And that leads directly to the third point, the adversarial collapse. The justice system relies on opposing sides checking each other's work. When the prosecutor hallucinates the law, the defense attorney admits he didn't read the citations, and the judge signs the order blindly, the structural integrity of the court simply fails.
And fourth, this idea of procurement as anti-regulation. The GSA's March 2026 Basic Safeguarding Clause and the DoD's February 2026 War Against Anthropic clearly demonstrate that the government's desire to be an unrestricted consumer of AI completely overrides its stated desire to be a responsible regulator of AI.
So it leaves us with this question, one that I think listeners should really grapple with. If the federal government is actively using its massive procurement budget to force AI companies to strip away their safety guardrails, how can we possibly trust that same government to regulate AI safety for the public?
It's a fundamental tension at the heart of our current AI policy.
That's all for Law and the Machine. Join us next time as we continue exploring where AI and the law collide. If you found this useful, subscribe and leave us a review.
The law will catch up, eventually.